Hi, I'm attorney Sherri Stinson, your Palm Harbor estate planning attorney. And today I want to talk to you about why estate planning matters, even if you think it doesn't. Now, if you're new here to the channel, I'd like to welcome you. And if you're a returning visitor, welcome back. I promise you, we've got lots of good information in store for you. All right, so why does estate planning matter? Number one, Florida has a pretty unique legal landscape when it comes to how things are inherited. And if you don't have a plan, the state of Florida will make one for you. Now, I often hear people say, you know what, Sherri, I'm too young. I don't need to worry about this. But the truth is, an accident can happen at any time. I have lots of clients who are healthy. Maybe they're out biking every day, they're doing lots of traveling, and then the unexpected happens. I always say, you're never too young, you're never too old, but you might be too late. When an emergency happens, you don't want to wonder about who's paying my mortgage, how are my bills getting paid. Maybe it's who takes care of my kids or my grandkids or my spouse. There's lots of different things that can happen, and you don't want to wait. Number two, I often hear people say, you know what, I don't have enough assets. All I have is a car, I have a home, maybe I have a small bank account and a small retirement plan. But the truth is, even if you don't have any assets, you still need an estate plan, because if you are alive but can't take care of yourself, the state of Florida might be in charge of saying who gets to take care of you and who gets to pay your bills. The second thing is, if you have assets, and most people do, they just have basic assets, what you don't know really can hurt you. In Florida, for example, we have lots of blended families, and some people think, you know what, I don't need an estate plan because my spouse will inherit everything. However, if you have kids from a prior marriage, that's not necessarily true without something in writing. Your spouse might only be entitled to half of what you own, or they might only be able to use the house for their life, and then we have another probate issue on our hands. So it's not always true that your spouse gets everything, and you don't want to be caught in the middle of a probate paying lots of attorney's fees and getting that time drug out forever just because you didn't take the time to make a plan. Number three, it gets really expensive and very complicated very quickly. People don't know filing fees in Florida are generally a couple $100, not to mention various publications that you might have to do, attorney's fees. Even on a modest estate, the presumptively reasonable fee averages out to around 3%. Now, that's not an exact number, but just imagine on a $500,000 estate, that might mean that your family pays $15,000 in attorney's fees, and that's money that could otherwise go to the ones that you want to inherit it. You know, I often find people say, I don't know where to start, or it's too overwhelming to think about. I want to assure you that it's not as overwhelming as it might seem. With the proper guidance and having an attorney help you figure out the who might take care of things and the what you own, it really isn't as complicated as it sounds. So I know you have questions after watching this video. I invite you to give my office a call or visit our website today, and we'll help you figure out the next steps. Thanks for watching.